It's great to be here. It's so great to be in this space. And I just wanted to start with, how I view my role in this space. And I go back to first principles, right? I go back to why the National Labor Relations Act was enacted in the first place. It was enacted during the Great Depression. Why? Because workers lacked channels of communication with their employers to improve their working conditions. And it was leading to a lot of industrial instability, labor unrest, wildcat strikes. And so Congress, thankfully, figured out that we need to level the playing field between employers and their employees, and we need to give workers rights. And workers have the right, under my statute, to bargain collectively through representatives of their free choosing and to freely associate with one another to improve their working conditions. And so we enforce a pro-worker statute. And what Congress was hoping and what happened was that through negotiated wages and benefits, we know that represented workforces earn at least 7 to 10%, if not more, than their unrepresented counterparts. The wages and benefits that those workers got and workers get when they are in represented facilities make them better consumers, and then they contribute to the failing economy. That was the goal back during the Great Depression, and it's the goal, part of the goal now. And we know that through unionization, there's a reduction in gender and racial pay gaps. There's a reduction in income inequality. There's a reduction in job turnover. There's an increase in job satisfaction. There's an increase in production because workers are sharing in the risks and the rewards of their performance. Unfortunately, though, what we see too often at the agency is that these low-road employers do not want to share their profits with the workers that are adding the value and actually keeping them profitable. So instead, what they do is they engage in union avoidance strategies. We see it all the time, where there's a nation organizing effort going on. The employer fires the union activist at the workplace, isolates the union activist, disciplines, suspends, and then on top of that, the worker gets the employer gets all these workers en masse. See, I knew I was going to start walking. All right. And forces them into captive audience meetings where workers who are being told why unionization is bad in their workplace, and being threatened, if a union comes in, we're going to have to close. If a union comes in, we're going to lose customers. If a union comes in, we're going to have to lay off some of you, if not all of you, move the work elsewhere. And they engage in these threats, coercion, intimidation, which is all unlawful under our statute, and we go after workers that do that, including going into district court seeking injunctive relief. But I believe that the actual holding of these mandatory captive audience meetings where economically dependent workers are forced to listen to their employer's anti-union rhetoric when they have the right not to is a violation of their right, and under our statute, of their right to refrain from listening to that. And so I've briefed this before the board. The board is different than the general counsel. I'm the chief prosecutor. I brief the matters, bring them to the board, and then the board members have to adjudicate. Now, I hope they agree with me. My positions are extremely reasonable, so I don't know why they wouldn't. But, we'll see what happens there. But I think that that would be a game changer, because then employees can choose whether or not they want to listen to that. But they're not mandated to go with an implied threat of reprisal if they don't. They don't go, or they leave early because they don't like what they're hearing. What the board has done in agreeing with me that we need to address the abuses of our processes that employers engage in to avoid unionization is they just issued a decision in a case called Cemex, which makes the process easier for workers to unionize. And in that case, workers are organized, want a particular union, the union gets majority support of that unit, the union goes to the employer, seeks voluntary recognition, which is the easiest path, and the employer has one of two options. Can either voluntarily recognize, that's what I would encourage, and engage in good faith bargaining, or they can file a petition with us if the union hasn't, and we will conduct a board election. If the employer does nothing, doesn't recognize, doesn't file a petition, the union doesn't have a petition on file either, then the board will issue a bargaining order because that union enjoys majority support. And then the employer will have to bargain. No election, no nothing, board ordered bargaining. If a petition is filed and we conduct a board election, or we're in the process of conducting a board election, and the employer engages in these unlawful activities, firing of the union activists, threats, et cetera, to undermine the union support, then again, we will, if we find the violations, then the board will again issue a bargaining order forcing the employer to bargain so that they don't gain from their bad behavior. So that's what the board has done. Great, I'm putting out a memo on this whole issue today, actually, after this. I just have to read it one more time. But the one thing so that's been helping. It's restricting, in some part, employers' avoidance strategies. But it's not deterring them fully, and that's because, at least in part, that, obviously you want to organize, and if employees want, a union to represent them in negotiations with their employer to improve their wages and working conditions, and that choice should be respected. But on top of that, when it comes to employers who refuse to bargain, it's one thing to organize, but the goal is to bargain, right? The goal is to get a first collective bargaining agreement that's going to inure to the benefit of the workers. And we see way too often that the employers employ the delay strategy. We're not going to recognize, well, they may be, let's say we have an election, the union is certified. They're not going to bargain with the union. Nope, we're not going to bargain. We investigate a charge, goes to the board says they're unlawfully refusing to bargain, the employer appeals it to the circuit court says the employer is unlawfully refused to bargain. 2 years, 3 years. And what does the employer have to do during that time frame? What is the remedy for that unlawful failure to bargain with a certified or recognized union? Bargain. Now, what good is that remedy? How is that going to deter low-road employers from engaging in bad behavior? It actually provides them perverse incentives not to comply with the law, right? Because what do they gain during the delay? Well, they don't have to pay out any of the increased wages and benefits that the workers would have gotten during negotiations. They get to undermine the union because the union can't bargain because the employer won't let them, so union renders them, the union basically ineffectual. They get to undermine confidence in my agency who certified this union 3 years ago, and the workers are seeing nothing for it, right? So my opinion on this is that we need to hit employers in their pocketbooks. We need to make sure that the remedy is that employers are required to pay these workers for the lost opportunity that they would have had in making gains during negotiations to improve their wages and working conditions as if the employer had bargained in good faith. So what that means is look at a comparator collective bargaining agreement, same geographic area, same industry, same classification of workers, and say, this is what a high-road employer did, negotiated. You're going to be required to pay your workers that money now and now bargain a collective bargaining agreement with the union. I think if we can hit these employers in their pocketbooks, we will deter more violations. Now again, I've briefed this to the board. They haven't issued a decision. You understand it's extremely reasonable, makes perfect sense. So let's hope that the board moves on this and moves quickly, because honestly, you know, it's those on the ground that are feeling the effects of all of this, right? So, I'm out of time. All right, well, anyway, I will close with, I knew I was gonna go over. I said, I have a feeling I'm gonna go over. So what I'll close with is just, you know, look, I had been with the agency for over 25 years, short stint out of the agency while the Trump administration was in. And, you know, my goals are the same as they were when I started in 1995, which is educate, protect, and enforce. And knowledge is power. There is strength in numbers. Workers are not alone, and we need to do everything that we can to empower workers so that they feel comfortable elevating their voices about issues of common concern, and we need to promote employers to not only listen to those issues, but to address those issues and to respect their employees' choices about unionization. That is the way you diminish workplace conflict. That is how you recognize the value that workers add to their employers' operations, which not only benefits the workers, but it benefits their families, communities, the nation writ large. So, you know, as is said here, we need to be bold. We need to be activist. We need to help workers strive for and attain the gains and the successes that they richly deserve. So thank you very much for all you're doing. Keep it up. Appreciate it.